Last year, and boy, it sounds so strange. Last year, it was only 2 months ago, the North Carolina legislature had proffered 6 constitutional amendments, 2 of which were defeated, 4 of which were approved by the voters of North Carolina. This past week, a state judge, and I'm seeing the headline, I'm confused by it, but we'll get to this in a moment, brought to you by the North Carolina Policy Watch. A courageous judge taps the brakes on a rogue General Assembly. And this, of course, Judge Collins announcing that 2 of the constitutional amendments approved by the voters of North Carolina have, in essence, been set in abeyance. They have, basically, he is putting them aside. I'm curious as to why our guest, Rob Schofield, has authored this article with the North Carolina Policy Watch. So we've asked Rob Schofield to join us this afternoon, and I'm always working on Rob, and I think I've almost got him convinced. But with that, Rob, good afternoon. Thanks for joining us.
Hey, Lockwood. It's good to be with you. Thanks for having me.
Always a pleasure. All right, let's talk about this article related to a courageous judge tapping the brakes. Why is what's the background on this?
Sure. When the General Assembly passed the constitutional amendments that it placed on the ballot last year, it did so admittedly had already been ruled by multiple judicial bodies that the legislature was actually illegally elected. It was an unconstitutionally gerrymandered legislature. It had been done for racial purposes. The courts had declared it unconstitutional. The only reason that we had them elected in unconstitutional districts is because the courts couldn't, get their act together fast enough to order new maps. Indeed, that's why we went ahead with the 2018 election with unconstitutional districts. The premise of the lawsuit was pretty simple and straightforward. It was a new issue, a new argument being made in North Carolina, but it's a good one. The argument that was made by the plaintiffs is, how does a legislature that is actually not constitutionally empowered, it's been elected with unconstitutional districts, how does it go about amending the state constitution? Now, it's one matter to, pass a bill to keep the government running, but to actually impose or to put forth an amendment that will change the Constitution permanently, the plaintiffs argued that itself is unconstitutional, and that's what Judge Collins ruled in his ruling last week. He agreed with them. He said that was an illegally constituted legislature. He says an illegally constituted General Assembly does not represent the people of North Carolina and is therefore not empowered to pass legislation that would amend the state's constitution. It was a pretty simple, very limited ruling. We'll see what happens. Obviously, the defendants are beside themselves, and they'll be challenging it, and we'll go up through the appellate process and see what happens.
But, Rob, let's start with the fact that there were 4 amendments that were approved by the voters of North Carolina. That's number one. Number two, only 2 of those 4 have been set aside or put in abeyance. What about the other 2 that were passed by the voters of North Carolina and are allowed to continue?
They weren't the subject of the lawsuit. If somebody wants to bring a lawsuit to challenge those 2 amendments, I suppose they could as well, under the logic employed by Judge Collins.
But the logic of that doesn't make there is no logic in that. If as you argue, which I disagree with, of course, if as you argue that the legislature did not have the privilege of introducing these amendments, in essence, they had no privilege to introduce any of the amendments. So the judge, at the very least, should have set aside all of the amendments that passed, and for that matter, even those amendments that did not pass. It makes it defies logic for him to say, well, the other 2 amendments that were again, air quotes, initiated by an unconstitutional legislature, we can continue with them. I have a hard time with the logic of that.
Well, here's another way to think about it. There are all kinds of laws passed in North Carolina, in Congress, that are arguably unconstitutional, but they stay on the books because nobody challenges them. Courts don't have authority to bring issues before the court that aren't brought to them by the plaintiffs. They don't have the right in American jurisprudence to simply pick issues out of the air and say, I'm going to rule on this because I think this law is unconstitutional. The way our process works is that someone has to bring a lawsuit to bring it before the courts. And so the judge didn't have the power to do that. He didn't have those issues before him in the lawsuit. But if someone wants to bring that lawsuit now, then presumably it might well be found, might get the same result.
I have to wonder why they didn't bring that lawsuit, but I would argue that, again, it doesn't quite fly in the sense of logic. I've got another question I want to bring up, but first, let me go to a caller standing by. I haven't heard from him for a while. Dennis in Jacksonville. Dennis, good afternoon. By the way, Rob Schofield with us, and of course with North Carolina Policy Watch. Yes, sir, Dennis.
So good afternoon. So here's my question. So was the lawsuit that was brought challenging the ability of this legislature to put forth amendments, or was it challenging the amendments themselves?
It was arguing that these two amendments in question were put on the ballot by a General Assembly that did not have the authority to do that. So they're saying there's no way that. Oh, go ahead. I'm sorry.
No, sorry. So the actual lawsuit says that it's not saying that the amendments themselves weren't valid. Mm-hmm. It's saying that they did not have the authority, constitutional ability to bring forth the amendment.
Right. You could probably concoct another scenario in which somehow there was a procedural flaw in an amendment going on the ballot, perhaps. We could come up with lots of them. That's what it's akin to. It wasn't attacking the substance.
So he was basically saying that these folks were illegally elected.
Right.
Oh, yeah. Well, I think that's already been well established. The question is,
no. That's been well argued.
What is the impact of having an illegally elected General Assembly?
So based on his ruling, somebody could bring forth and challenge all members of the current legislature as being unduly elected, and he would rule in their favor.
Well, no, that's already been done. There's already been a lawsuit that says that the legislature was elected illegally and unconstitutionally, and the courts are in the process of fashioning a remedy for that, which basically means we're going to have some properly drawn constitutional maps that will elect legislators in a way that's not racially gerrymandered.
Well,
that's already been dealt with.
That's already.
Wait,
they were already elected.
Okay.
So if they were already elected and it was done illegally, the remedy is not to redraw the maps. The remedy would be to invalidate every single official elected based on this judge's interpretation.
And by the way, I've got to jump in on this one. Rob, I disagree on the issue of it was racially gerrymandered. It was politically gerrymandered, according to the courts, not racially. That's number one. But number two, and I've got to go back to something else Dennis asked a few moments ago, and I think the operative word here is all. That means all members of the legislature, Democrat and Republican, need to rerun for their office in a more, if you will, more equitable or whatever you want to call it, district breakdown. But I have to say that any and all actions of this legislature, including the current legislative session, now is to be scrutinized. Back to you, Rob.
Well, again, somebody is free to bring that case into the court system. As to whether a judge is going to go that far, this judge was very careful in making a very narrow ruling. They didn't purport to invalidate all the actions of the General Assembly. They just said that, and if you think about it, it makes sense. How far, if a General Assembly can be elected in an unconstitutional way and then theoretically rewrite the whole state constitution, submit something to the voters that completely rewrites it. Where do you draw the line?
It's happened.
The judge was making a very common sense ruling that it makes sense not to allow a legislature that was illegally elected to amend the Constitution.
Well, go ahead, Dennis.
Then based on what you're saying, he didn't go far enough. No, because either they were or they weren't.
The judge can only deal with what's been brought.
All right, okay, I understand. Yeah, go ahead, Dennis. Go ahead,
Well,
Rob.
The problem is that the original lawsuit said they were elected illegally, correct?
Mm-hmm. So therefore,
and they were found. Yes, they were elected illegally. But the remedy wasn't to nullify the whole election. The remedy was to change the districts.
Right.
So this judge has taken a leap past that and determined that they can't take actions as legally elected members of the legislature. So he's made that determination. Why would you not go ahead and take the next step and just say they're all there illegally?
Right.
Because that's what they
Somebody
said.
could.
I mean,
that's just not. I'm not doing that. That's not what the plaintiffs in this case did. They brought a very narrow lawsuit in hopes of invalidating. They didn't want to upset the whole apple cart of state government. People realize we have to have a government that's functioning. But when it goes to the extent of permanently amending our Constitution, I think there's a distinction to be made between passing a run-of-the-mill bill that obviously the courts have to fashion remedies that make sense, that allow our government to work, that allow basic public functions and structures and services to go ahead so that government isn't completely paralyzed. So it makes sense that courts can draw lines. And in this case, I think it sort of makes sense that they're drawing a line between, in effect, between a run-of-the-mill appropriation that would last for a year and a permanent change to our state constitution. Now, admittedly, this whole thing is the judge himself admitted this was a case of first impression, which is a fancy legal way of saying, we haven't done this before. This is an issue that really hadn't come before the courts before. It's a somewhat surprising ruling. I admit that. I think even people who are very receptive to it think that it's a creative ruling. It's obviously going to be appealed to the higher courts. There's a chance it may be overruled. But I thought it was a strong opinion when I read it. It was a very limited opinion, and I think it definitely shines another light on the fact that we have, had for a very long time an illegally elected General Assembly, and by golly, we need to do something about that. That's the ultimate remedy here, is to stop having gerrymandered electoral districts.
Dennis, thanks very much for your call. I appreciate that. Good points. All right. Rob, real quickly, just a quick note on this. This is not unusual relative to gerrymandered districts. We had them for almost 150 years under a different administration, that being Democrats. And it's just to find this all of a sudden that it's evil and illegal is kind of a false description. But
here's what I'll say about that. A lot of us, both conservatives and progressives, have been arguing for a long time, even when the Democrats were in control. My organization argued very forcefully that we had illegally gerrymandered districts, that we needed to have nonpartisan redistricting. You're right. This is the guy who this was named after, Elbridge Gerry or whatever his name was 150 years ago. This has long been a problem. The difference, though, in recent years is that with the advent of modern digital technology, we have gotten so much better at it, and the Republicans happen to be the ones in power right now. There are Democrats in other states that are doing this and have perfected it to an extent that is robbing people of their right to choose who represents them, and that's what we've got to do away with.
I argue that it's perfecting it. The robbery has been happening, as you said, for over 100 years, no matter what.
But doggone it, it's past time to do something about it.
But the other aspect, and I got to correct this, the gerrymandering is based on political lines, not racial lines. That's number one.
Those are the cases that are before the U.S. Supreme Court right now. But North Carolina has also had a series of rulings that they have found that there was explicit racial gerrymandering in North Carolina, and that was unconstitutional.
But you see, I disagree with you on that one, simply because the districts, as they were first drawn, they've now in their, I think, third iteration, were approved by the Justice Department. So I have to disagree with you on that one as well. But I want to go to one other key element. This is a big one for me. This is the fact that the voters of North Carolina chose to support these amendments, regardless of who wrote them or whether they were right-handed or left-handed. And if you're not aware of this, I'm extremely concerned when I'm around left-handed people, but that's for a topic of another time. But the point is, these votes were taken and approved by the voters of North Carolina. Is this not, in many regards, sort of thumbing the nose, the collective nose, if you will, of the judiciary at the voters of North Carolina? This is disturbing.
I just don't think at all that's at all the case. The voters the voters can only deal with what's in front of them. They voted at that time, but the voters also have a right to expect that when amendments are placed on the ballot, it will be done in a constitutional way. They don't have a means of checking that. They go to the ballot box and they vote for what they vote for. But I would think everybody in our state would be united and unified in agreeing that, my gosh, if we're going to amend the Constitution, it needs to be done in a constitutional way, and we've got to have an ability for our judiciary to place a check on that. And in this case, I think they've found that there was a flaw in the way the amendments went on the ballot. If they're that popular, we can just pass them again with a legally elected General Assembly and do it again, and we'll have the same amendments and we'll pass them.
We'll see. It's actually it's one judge making that decision. And I think you touched on another topic. It is, I'll use the word creative, judicial thinking and arguing, but I find it fascinating. All right, with that said, Rob, as always,
Thanks,
it's
man.
a pleasure talking with you, and I appreciate your time. Rob Schofield.
Back at you.
You got it. Thank you. We'll take a quick break on that. All right, let me just drop that one here and get on with some other conversations. I know we've got some calls coming in. We'll get to those calls here in just a moment. I've also got Ray Nothstein joining us. I want to talk with him about last night's State of the State address by the governor. More to come here on Viewpoints. And to the callers standing by, we'll get you on. Hold on with us.